basically the entry and direction of travel front to back, these sorts of things, while yes, it may be consistent with somebody facing away or facing towards, that's with the understanding that anything that's in the normal realm of motion, could create what you would call a back to front or front to back, but the body could be twisting, moving around, anything within the normal range of human motion, correct?
That's correct, yes.
Okay. And so the trajectory on C is downward, and the trajectory on D is front to back, and again, within the range of normal human motion, that could be consistent with an individual facing the muzzle of the gun.
Were we talking about
The toe,
being shot in the back while you're facing the gun?
no. I was referring, Doctor, to wounds C and D.
C and D, okay.
Yes.
C, could he have been facing the gun when he received, C is the gunshot wound between the toes, so could he have been facing the gun when he received that wound?
Is that within the realm of possible positions
I guess so.
in a fluid world, Doctor?
I suppose so. I mean, I have no objection to that, sure.
Okay. And no objection to the same thing for D with the front to back travel, correct?
D is the one in the right lower leg that's going upward.
Do you have any real problem agreeing with that possibility, Doctor? Just yes or no?
I have a problem with that one. Yeah, because if your body is turned, it doesn't mean your leg is turned. So.
But it could be in the normal range of human motion.
Sure. Okay.
All right. So, Doctor, can you just explain for the jury the definition of homicide?
The definition of homicide is that your death was a result of somebody else doing something to you.
So, in other words, it could be, in another way, explained as one person causing the death of another person.
One person causing the death of another person is a great explanation.
Okay. And so that would include situations of involving criminal conduct like murder, right?
Yes.
And it would also include situations of non-criminal conduct, situations that might involve self-defense, correct?
I'm not understanding that.
The definition of homicide.
Can happen during the act of self-defense.
Correct.
For instance,
Can one person kill another person acting in self-defense is the question.
I see. All right, that's possible, sure.
Okay. And that's consistent with the definition of homicide, which you ruled as the manner of death here.
Yes.
Thank you. And you found no evidence of any defensive wounds in this case, correct?
No evidence of defensive wounds, that's correct.
May I have a moment, Your Honor? No further questions, Your Honor.
Redirect, Mr. Will.
Couple quick questions. Okay, Doc, no definitional wordplay about homicide. I promise that. You told us that the time from the time that the body was received by your staff to the time that it was checked in was only 5 minutes.
Yeah.
Do you know that this actually occurred within a mile and a half of your office?
Wouldn't be surprised to hear that. Yeah.
Mr. Mott just asked you a second ago about, and I think both attorneys actually, about how these wounds could have been received and what the anatomical position was and that kind of thing. All these wounds can be explained quite simply if you just take into account one thing. And in this hypothetical, it would be Brian Leverett running away from the gun that was firing at him.
No, absolutely, yeah.
And no matter the anatomical position, the middle of the back is still the middle of the back.
It is, yes, it is.
Thanks.
Okay.
Here we release Dr. Gallagher from the subpoena.
Yes, ma'am.
Any objection from the defense?
No objection. No objection.
Dr. Gallagher, you are released from subpoena. You're free to go.
Thanks, sir.
Mr. Will?
State rest, Judge.
All right. Ladies and gentlemen, let me give you an update on where we are. First of all, once the state rests its case, the court is required to address some legal matters with defense counsel. So that will take us some time. In addition, I have, at every single break, attempted to get an idea from the attorneys where we are in the case for updating you for scheduling purposes. The good news is that the testimony will be concluded tomorrow. The bad news is the trial will not be. We will be required to return on Monday. What we anticipate happening is a few hours of testimony tomorrow. We're not sure exactly how much. After the conclusion of that, the attorneys and I have to have what's called a charge conference. That is where we determine what the appropriate jury instructions are to give to you. That cannot be done until all of the evidence has been put in. I can't predetermine what's going to be the evidence. I have to wait till I've heard it and then determine what the law is. Right now, there are 50 pages of jury instructions. So there is no way that we are going to be able to turn this around in 30 minutes, an hour, or even 2 hours. Plus, my assistant has to type them once they are edited. So what we anticipate tomorrow is sometime early to mid-afternoon, you being released for the day, because we will have to conclude that charge conference and have the jury instructions prepared. With the understanding that on Monday morning when you report, we would be going directly into closings and deliberations. We will be done on Monday. That's not the issue. The issue is we're not going to be done tomorrow. I understand that may not be in line with some of the information that at least those of you from the first panel that we saw last Monday. We told you 2 weeks, which would be concluded tomorrow. But I'm trying to explain to you the reason why it will roll over into Monday, but it will not go past Monday. So that is the update. Deal with any issues that you may have regarding your schedule. Alert me tomorrow if there are any major problems with that. We attempted to inquire of your schedule going into next week, but this is somewhat of a new issue for you, so I just wanted to bring it to your attention. We can address it tomorrow. Now, I will tell you that, again, we have to address those legal matters, and so we're not going to be able to start at 8:45 tomorrow. I'll ask you to report at 9:15. I do believe we'll be ready. We will be able to conclude those and be ready for you by 9:15. So there's no reason to get here as early as you have been, and I appreciate you getting here that early. But there's no need for you to do that so that we can be done and ready to start when you arrive. So 9:15 tomorrow. It will be a shorter day for you tomorrow. I can't give you an exact schedule, but it will be a shorter day so that we can conclude those other matters and be ready to finish out on Monday. Does anybody have any questions at this point? All right, subject to all prior instructions, you are released for the evening. We'll see you at 9:15 tomorrow. Any issues that we need to address before we meet back tomorrow at 8:30 for motions? Oh, sorry. Thank you.
Juror number 2 earlier today told me that she has been terminated from her employment due to this case affecting her being at work. And she wanted to know if there was any remedy that she could ask you about her employment terminating. And I said that I would pass that information on.
Judge, I cannot give her legal advice. She needs to consult an attorney. After the trial is over, she may be able to speak to various attorneys about it. She will be given and I'll try to address juror number 2 without getting into specifics tomorrow. But she'll be given her jury excuse to prove that she was here. And the best that I can do is tell her that there is a law against that, but that I can't assist her with that. And she'll have to get legal assistance to address that. I don't know, would it be inappropriate for any of the attorneys here, after the trial's over, after everything is done, to provide her with a list of people that have
Judge, I can give you a couple of referrals, and I know out of attorneys who
obviously it needs to be somebody dealing with employment law.
exactly literally foam at the mouth to take care of something like this. This is ridiculous.
Right. And there's a clear law, but again, we can't even talk to her about who or what, and I can't ever talk to her about that. But we'll get her a list. Perhaps we'll do it without the source being identified, but perhaps if the attorneys could come up with a list. My office will type it up and we'll just put it in an envelope for Deputy Merchant to hand to her. We'll explain to her it came from consultation of the attorneys, but she won't get it till afterwards. So but remind me of that tomorrow, and I will attempt to address juror number 2 before we start, just to give her our condolences and that we'll assist her as much as ethically possible in that regard.
Ms. Schuler noticed that she was crying when she came back from lunch because she had mentioned it to me, and
I did not notice it.
so,
See if I can remember where she worked.
I don't
Figure that out.
She was behavioral, was it behavioral, or she was a teacher?
She's a
Something to do with
teacher, I think.
her. Was like that.
Oh, you're right, behavior analyst. I don't believe she told us specifically where she worked.
Is there any indication she made any comment about it because of hardship?
Not at all.
Let
No,
everybody
she didn't.
know.
She did not.
She was actually the only person who raised her hand and said she wanted to be on the
Yeah,
jury.
she did.
All right,